Good afternoon and welcome to Virtual Face-to-Face with President Bruce Jarrell. I'm Alex Lukowski, Assistant Vice President for Communications. JFK first used the term affirmative action the way we think of it today in an executive order in 1961, but it was his successor, Lyndon Johnson, who gave the first full-throated explanation of the reasoning behind it in his commencement speech at Howard University the year after signing the Civil Rights Act of 1964. Johnson talked about the long history of discrimination against Black Americans and the special nature of the poverty thrust upon them. And to make up for that, he said, equal opportunity is essential, but not enough. We seek not just freedom, he said, but opportunity. We seek not just legal equity, but human ability. Not just equality as a right and a theory, but equality as a fact and equality as a result. For decades before that speech, of course, the doors were closed to students of color, certainly elite and many other historically white institutions. Affirmative action didn't magically fix everything, of course, but over time, a great deal of progress has been made. Progress, but not equity. Now, the big reason we're here, of course, is that in October, the Supreme Court heard arguments in two cases that could change how and even if universities can consider race in deciding whom to admit. This isn't the first time, of course, the High Court has heard this issue. The 1978 Bakke case against the University of California upheld using race as one of many factors to consider, but it drew the line at quotas. In 2003's Grutter case, justices upheld Bakke, sort of, but writing for the majority, Justice Sandra Day O'Connor said the use of race as a factor was a permissible thing because it furthered a compelling interest in obtaining the educational benefits that flow from a diverse student body. So we were no longer talking about affirmative action, but really race-conscious admissions for the benefit of the whole student body. And there have been other cases upholding the use of race-conscious admissions, but that was before a supermajority of conservative justices appeared, some of whom I think it's fair to say hammered attorneys for Harvard and the University of North Carolina in October. Justice Clarence Thomas told Harvard's attorney, "I've heard the word diversity quite a few times, and I just don't have a clue what it means." And Justice Sam Alito asked for the definition of the term underrepresented minority. And they repeated arguments previously appearing in dissenting opinions that granting a student an advantage based on race, any race, is constitutionally prohibited. Well, I'll leave the analysis to the experts. But it's important to note that much of the conversation also centered not on if race-conscious admissions in higher ed should be eliminated, but when. They talked about another part of Justice O'Connor's Grutter opinion. Court, she said at that time, expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. Now, liberal justices have never accepted that or any other timeline, but Justice Elena Kagan argued admissions to elite universities are the pipelines to leadership in our society, adding that she feared that completely eliminating race-conscious admissions would lead to a precipitous decline in minority admissions. And history is on Kagan's side. In 1996, Californians voted to approve Proposition 209, which banned consideration of race, sex, ethnicity in public contracting and publicly funded education. Almost immediately, enrollment of students from underrepresented groups in the University of California system dropped 12% on average, at some schools as much as 60%. And since then, 8 other states have adopted similar bans or restrictions on race-conscious admissions. So what might the court do? And if race-conscious admissions are outlawed, what can we in higher ed do to build and maintain diverse student bodies and hopefully one day an equitable society? We've got quite a collection of UMB brainpower to help sort that out today. From the University of Maryland Francis King Carey School of Law, Dean and Professor Renée McDonald Hutchins, and University System of Maryland Regents Scholar, Professor Mark Graber. Let's also welcome Diane Forbes Berthoud, Chief Equity, Diversity, and Inclusion Officer and Vice President. And you may have already noticed the absence of the program's namesake. He's entrusted the reins to none other than Roger Ward, our Provost, Executive Vice President, and Graduate School Dean. But before he takes it away, as brilliant as our guests and our host are, your questions and your thoughts are very, very important. Later in the program, we'd like to hear from you, so please write me in the chat area. I'll let you know when we're ready to hear from you. Just be sure to tell me if you want to remain anonymous. And of course, I need to tell you that the program, if you didn't hear, is being recorded and will be posted on our website. Roger?
Thank you, Alex, and welcome, panelists. Thank you for taking the time, making the time to participate in this very important discussion. Thank you, participants, those of you who are tuning in live, and the many hundreds of you we know eventually would view this as a recording. We appreciate you taking the time. As always, Alex, fantastic job setting up the conversation and providing the relevant background and context. This is a really important conversation. It's perhaps not the conversation going into a holiday season you want to be heading into a holiday season talking about, because depending on your perspective, it could be a sobering conversation, but it's an important conversation nonetheless, and one that we are compelled to have as an academic institution, and certainly one located in Baltimore, and one that cares so deeply about issues of equity and justice. So why do we care about this topic? Because if predictions hold, it is highly likely and possible that the US Supreme Court, whether it's early next year, February, as some have suggested, or later in the year, in June, when they tend to release their most controversial decisions, it is possible that at some point next year, before the current term of this court ends, the court could overturn close to 50 years of precedent as it relates to affirmative action, and in so doing, impact programs that flowed from that precedent that over time have attempted to level the playing field for folks, individuals, groups of people who have historically been discriminated against. And so that is what is at stake as it relates to the decision pending before the court. And this is why we're here to have this very important conversation. We want to leave time, of course, as Alex says, for questions, as he said, for questions. But I want to turn first to Professor Mark Graeber and ask Mark to help us frame this issue and understand this issue of affirmative action within the context of the U.S. Constitution and any applicable statutes attendant here to this particular issue, and then perhaps talk to us some, by way of just setting a baseline understanding of the legal issues, talk to us about the relevant case law that have gotten us to this point as it relates to affirmative action.
Thank you very much. The history of affirmative action is one of ambiguity and compromise. So consider even Brown versus Board of Education, which is the foundation for the law of race discrimination in the United States. On the one hand, the plaintiffs in Brown talked of race as not being relevant. And so if race is not relevant, we ought not to classify or judge people by something that is not relevant. On the other hand, the plaintiffs talked about racial classifications as stigmatizing. Well, racial classifications do not stigmatize white people, they stigmatize persons of color. This seems to imply if we use race in ways that does not stigmatize, that is constitutional. We see some of this playing out in the first major affirmative action case, Bakke versus Regents of California. University of California, Davis had a new med school, and they reserved 16 seats for students of color. 4 of the 9 justices said this violated federal law. They did not get to the constitutional issue. They said this violated federal law. 4 other justices said there was nothing unconstitutional about this, given the massive societal discrimination against persons of color in general, and against persons of color in the medical profession. University of California, Davis could set aside 16 seats. The 5th vote On a series of distinctions, it's important to understand no other justice made was Justice Lewis Powell. Justice Lewis Powell rejected the claim that a state university could make decisions and use race on the basis of societal discrimination. A state university, he said, could only remedy their own discrimination. But because the University of California, Davis was a new school, it had no history of discrimination, and he said there was no other finding of discrimination. But he said there was a second value, diversity. Educational diversity, the right of an academic institution to decide the best way to educate students, that was a compelling interest. Now Powell said what was crucial was that didn't allow quotas. Rather, you could use a plus system, very much the way, say, alumni preferences, athletes, you get a plus, so everybody could compete for every seat. Very much, he said, what Harvard was doing. Not coincidentally, I believe, Powell either served or was on the Harvard Board of Overseers at the time. 25 years later, in Grutter versus University of Michigan, the court largely adopted Powell's framework, but with a couple of twists. University of Michigan followed Powell. They did not have a quota in the law school. Rather, all students had to write an essay on how they would diversify the law school. They did, however, have a policy that the University of Michigan wishes to enroll a critical mass of students from historically underrepresented groups. So you can see in some ways a little bit of societal discrimination coming in the back doors. In some way, what Justice O'Connor, who wrote the majority opinion, was trying to do was collapse the distinction a little bit. But in fact, it worked. Justice O'Connor did say, first, diversity was a compelling government interest that justified the use of race as long as you did not have a quota. Second, it was also reasonable for universities to seek a critical mass. A critical mass had two virtues. First, it prevented isolation. It made sure you were not the only member of your group in the classroom. Second, and I think more important, it was designed to combat the idea that all members of a particular historically disadvantaged group think alike. That if we have Dean Hutchins in the classroom, everybody else can be a white guy from Alabama because all blacks think like Dean Hutchins. They have always thought, and they will always thought. We just have that. The idea is we need a variety so people can see the full gamut of the African American experience, the Asian American experience, the Hispanic American experience. Now, it's interesting in Justice Ginsburg's, not dissent's, concurring opinion, she seemed to indicate societal disadvantage was enough. 3 justices dissented, my apologies, it was 4, and they went the more traditional route that the Constitution largely forbids race discrimination except for in extreme circumstances. So we're at a point now where the North Carolina case is a straight constitutional case. Justice O'Connor, Justice Breyer, who were the centrist judges, are off the court. They are replaced by conservatives. It's very doubtful they will accept the Powell Compromise. The Harvard case is a federal law case. Harvard is a private institution. It is not bound by the 14th Amendment any more than in our private lives any of us are. However, Harvard is bound by federal law. Federal law has anti-discrimination provisions that the Supreme Court has interpreted as being identical in scope or largely identical in scope to the 14th Amendment. So it looks doubtful that the Powell opinion, which is important to understand, was a compromise. But that compromise looks to be undone, just as this court has undone a number of other past compromises. I hope that helps.
That is incredibly helpful, at least to me, Mark, and I'm sure it is to the audience as well. Thank you for that very excellent framing of the issue. Dean Hutchins, I want to turn to you for your perspective. Of course, goes without saying, we know you're a highly accomplished lawyer in your own right, highly accomplished litigator, and you also happen to be the dean of a highly ranked school of law that cares deeply about equity and justice issues, that is committed to diversifying the student body. And so your perspective is especially important here. Talk to us from your perspective, especially as a dean, about why it is so important as an academic institution, as a school of law, to have a diverse student body. And why is that so important to the school, to the institution, and to society at large, that we educate a diverse student body?
So thank you, Dean Ward, and it's for a number of reasons. So I will leave it to my very able colleague, Professor Graber, to talk about the legal details, and I really am coming at this as an administrator. And one of the things that we know is that public confidence in the legal system requires that the bench and the bar roughly reflect the public that they are serving. And what we know is that the bench and the bar do not roughly reflect the public they are serving. So the legal profession is one of the least diverse professions in the country. About 5% of all lawyers in the nation are Black, even though about 13.4% of the US population is Black. Roughly same numbers for Latina attorneys, about 5%, even though about 18.5% of the population is Latinx. And only about 0.4% of attorneys are of Asian American descent, even though about 6% of the population is, right? So what we know is that the bench and the bar are not reflecting the public at large that the legal system serves. What we also know about diversity, and this is, I think, an important piece of it, and it goes to what Mark was talking about earlier in terms of Sandra Day O'Connor's sort of shift in terms of the importance of diversity. Diversity does not just benefit those who have traditionally been marginalized. Diversity benefits all of us, because what we know about diversity, what the studies tell us about diversity, is that when you are operating in more diverse spaces, you get better innovation, you get better service, you get better outcomes, that having a diverse pool of people or a diverse community leads for better outcomes for everybody. And so as we are thinking about educating the next generation of lawyers, it is important to us that we have a diverse student body so that we have robust intellectual engagement across any, right? It's the point that Mark was talking about in terms of the classroom. You need a multiplicity of viewpoints and perspectives walking into the classroom so that those engagements in the classroom are robust. We also know that we are training lawyers for a profession on the back end of their experience here. And that profession is going to be a profession that puts them in touch with a diverse array of clients, opposing counsel, judges. And so we want to make sure that students are not learning in a monolithic echo chamber. We want to make sure that they are learning in a space that allows them to hear and learn from diverse viewpoints and perspectives so that they are well equipped to step out into practice.
Thank you for that, Renee. And Dr. Diane Forbes Berthoud, UMB's Chief Diversity, Equity, and Inclusion Officer, is with us on the panel today as well. And Diane, I want to allow you some time to pick up perhaps where Renee left off and provide any additional context you may have as it relates to why, diversity both inside the academy is so important, and certainly educating a diverse student body, the impact that they then have on society. Any other research that is relevant here to support the idea that diversity is so valuable to us as a society at large.
Absolutely. Yes, so sure, happy to continue to extend the ideas from Dean Hutchins. One of the things we also know is that the teaching and learning environment is enriched. And in terms of the benefits of all, there's actually research about our cognitive and our physical development. And so research around mental and racial and marginalized populations trauma revealed that it actually alters how our brain functions, alters how we learn. Conversely, when there's a diverse environment, not only students, but our entire community grows and can really be in a position of, if you will, healing collectively. Another element is thinking about the reputational benefits of our institution, that we want to be known as public higher education institutions as caring about populations that have been traditionally excluded or structurally marginalized from educational opportunities, which is why HBCUs, historically Black institutions, were created, tribal colleges, women's colleges, and so on. And the other benefit is not to necessarily be capitalistic about this, but we are able to attract research funding and funding for scholarships and the kinds of things that show that we're committed to student learning and success and faculty and staff success and learning. So overall, to support that point, certainly we all benefit. And then finally, recruitment and retention of diverse faculty and staff. When we look at the student body, when we look at the institutions that many of us have worked in and out of over the last, 30 or so years, we're likely to attract a diverse group of employees, faculty and staff, to work, teach, grow, advise, mentor students, and to conduct research if our student body is also diverse. So that's certainly a benefit.
Thank you for that. And I want to stay with you, Diane. If we accept Professor Graeber's thinking that the new members of the Supreme Court will not embrace the Powell Compromise, and we assume that the court is going to overturn precedent as it relates to, again, close to 50 years of precedent as it relates to affirmative action and end affirmative action as we know it, we're going to be left as an institution and as leaders and administrators to grapple with it. And for many of us, it's going to be a new experience because, as you could tell from my youthful experience, my youthful appearance, I wasn't around before. Maybe I was a little around, but I certainly wasn't in higher education. Post all this case law that supported affirmative action. So a lot of this, all of it is going to be new for many of us. We have the benefit of having recruited you away from the University of California system. And so if the court does overturn affirmative action as we know it, many of us will be in a position, you and your colleagues in states like California that had propositions, in your case, in California's case, Proposition 209, going back to 1996. And so folks in California have been sort of like living under what many of us might end up experiencing in the coming months. Could you talk a little bit as an administrator in that environment, as an educator in that environment, what your lived experience was with Proposition 209 in California?
We're happy to. So for some context, for friends and colleagues on the line, I worked in the University of California system for 11 years as executive director, then assistant and associate vice chancellor. And not the lawyer at all, but I got the article to quote for people to, I'm like, what's Prop 209? It was just an everyday talk for us lingo when we were living and working there. So Proposition 209, 1996, I was in graduate school, not in kindergarten or anything like that, but I was in graduate school when this was passed, 1996, the voter initiative codified as Article 1, Section 31 of the California Constitution. Ooh, I can join the lawyers now. It prohibits the University of California or any university in the state from, quote, discriminating against or granting preferential treatment to an individual or group on the basis of race, sex, color, ethnicity, or national origin. That's the actual article. And so this proposition, we just call it Prop 209 for short, eliminated some of the tools that university previously employed to really diversify the student body. It's also about affirmative action programs in public employment or public education. It was more far-reaching, but we're talking about education specifically. What was the impact? There was a Washington Post article published a few weeks ago to summarize some of that, and then, as you said, my own lived experience. I was on the San Diego campus, but in the UC system, working up and down Route 1 for about 10 years. At Berkeley, for example, the Black share, if you will, of the first-year class fell by half. San Diego, just about the same, and UCLA, there was always a struggle for increased Black students or Latinx students. And so that fell in 1998 and then beyond. The Latino share, Latinx share of the student population, the first year class, took a similar plunge and went down to 7%. Why is this important? When I left California a year and a half ago, the share of Hispanic Latinx population was 40%. So to have it fall to 7, no, this was 20 something years, but I'll talk to you about where it went to up until last year, and I have the stats to this year as well. Placing that in the context, when we think about Maryland, we may find some of those single digits startling, and they are. The share of the Black population in California is about 5.8%. So when we get to numbers at 3%, those numbers have increased a bit, still small, but in terms of the fraction of the population, it's very low. What did we do to increase the share of the representation of those students, faculty, and staff, and also to attract more students? A number of things. Offices like Equity, Diversity, and Inclusion offices, both at the system level, the UC system level, and at the campus level were created. And so I worked in one of those offices a year after it was created. The office is close to 10 years old now. And leadership also created that at the system level. I'll start with what has happened now and how we got there. About half of the universities in that system are becoming or close to becoming HSIs, Hispanic Serving Institutions. That means that the student population needs to be at or close to 25% in order to receive federal funding and to have specialized programs for Latinx populations. There are 10 universities in the UC system. The campus that I was on became an emerging student population, an emerging HSI at 21, 22%, starting at about 16% and over three years increasing that. On my campus in San Diego, the African-American population doubled from all of like 1.5% to 3%. So building centers that focus on targeted and specific needs of students in particular populations around advising, mentoring, coaching. So Black resource centers, La Raza Centro, a women's center, and so forth. Centers being built to attend to the needs of students, both socio-emotional as well as academic and intellectual. Leadership is really important as well. Intensifying our messaging and our values and our actions around population-specific programs. And so I'll give you some examples. That programs that are targeted by race or gender, but operated and managed by private non-university organizations. So the San Diego Foundation or Habitat or some other organization that's not a public institution administering some of those funds and or aiding and providing scholarships for students. So in some cases, we were not able to say this is a Black student scholarship, but we might be able to name an issue that affected Black students, first generation or low income students, which would affect mostly students of color. That was not prohibited by the law. And so to be able to say we are interested in building programs or providing scholarships for those who are low income or students with no or little EFC, expected family contribution and financial aid, that's not racially coded or categorized in any way. However, our research shows us that the populations that are affected are those who are ethnically and racially minoritized groups. Another thing, one or two more things I'll mention before I turn it back to my colleagues, is using strategies such as cluster hires around, again, issues and program-specific issues. So the time of COVID in 2020, as an example, between funding from foundations, funding from the president at the time, Napolitano, and funding from philanthropic organizations, there was a cluster hire created around public health issues, health disparities related to COVID that affected, and then we named 2 or 3 populations, Indigenous, Black, or other populations. Well, who is more likely to be studying those issues? Faculty from minoritized populations. And so the cluster hire was for 12 cluster hire for faculty, and that was accomplished or is being accomplished, closing out now. And so that's another opportunity, as well as curriculum and program changes. So there will be lots of ways that we'll have to be creative in thinking about enrollment. And then the final thing, which being the campus that we had 2nd or 3rd highest enrollment in the UC system, although we were the youngest in the UC system at the time, is there was always a healthy competition among Berkeley, LA, and San Diego for minoritized students. And we would often say, well, why are Black students not choosing X campus or another campus? There was a more extensive study, but it was summarized in 2 words: money and love. What do you mean? Increased funding often brought students who were either first generation low income and or Black, Latinx, or Indigenous. And love meaning the kind of climate that's created for students and or the ways in which we approach the recruitment or the community building process. And so when students felt that, particularly at LA, Berkeley, and San Diego, they were more likely to choose those places to live and learn, and also creating things like learning communities. So lots of academic, intellectual, financial, socio-emotional elements that build all of those things and make those things happen. And we saw doubling of our enrollment and our presence of those students. And we also saw that we were moving, half of the universities have moved towards HSI, Hispanic Serving Institution Population designation.
Thank you. Thank you. I know we have questions, and Alex, maybe you want to use some time to tell folks how to get their questions in. Then I want to come back and just ask Mark to comment on, to break out his crystal ball for us, and then turn to the questions.
Am I on? Am I muted
Yes,
or
you are.
unmuted? Okay, this is the most vital question in the contemporary academies, whether you're muted or not. My first Swami prediction is one I'm going to make no money on because there's nobody betting against me. And that is, I would expect Grutter and Bakke to join Roe v. Wade on the dustbin, perhaps temporarily, one might hope, of history. I think there are 6 votes to overrule. It's hard to figure out where 2 justices that might agree in a compromise are coming from. The more important question, given everything Diane said, we can imagine 2 kinds of rulings. The first is you can't use race explicitly, but we have no problem if you design a program that you think will attract African American students, African American faculty, as long as the program doesn't use race. So you decide, for example, you want to do a program on the problems of inner cities. And there's some good chance that that might be more inclined to attract, say, African American students who grew up in Baltimore than a white kid who grew up in Idaho. The real game changer, and this has happened in Alexandria, is where the court says not only are we not going to allow the explicit use of race, but if we think the reason you adopted a program that never mentions race was because you wanted to increase the number of African Americans, Latinx. 1 second, I apologize. Just got a weird thing. My apologies for my computer, but if you adopt a program for the purpose, that's also unconstitutional. So in Alexandria, they had a magnet school. To increase the number of African American students, they simply adopted a policy that every school in the area, middle school, got to say, send 10 kids to the school. Word race was never used. Local court struck that down. If that happens, then it will be very difficult to develop programs to have a reasonable critical mass of students of color on any campus of any sort.
Thank you, Mark. Alex, questions?
Well, we have an anonymous question along the lines you're just talking about, Mark. Person writes, I've read one proposal that students be asked to write essays for their applications that explain how their background and experiences position them to improve the overall student body. So in other words, instead of just saying, well, because you are Black or Latinx or whatever, you get you write an essay and we're judging on your essay what experiences you bring. And they want to know if that's something that you've heard about. Is that a possibility?
Well, I can speak to that. That is part of what we call, and we use in the UC system as well. It's used elsewhere. It's not unique to that system, holistic admissions. And thinking about, from our perspective, race as intersectional with region, with income, with working experience, and so on. And from reading those stories, we'll hear all the things that we're talking about here, about what it is like to be in an urban community, about perhaps being low income or being disadvantaged or marginalized in some other way. And so if we have not only that dialogue, but train our admissions readers, I was one in a previous life, to understand what those things mean, we can enrich our incoming class so that we can have a more diverse environment.
I wanted to just speak to that point a little bit. So at the law school, we are very, very interested in ensuring that our classes are built in such a way that we are encouraging intellectual engagement across a wide array of viewpoints, perspectives, and worldviews and lived experiences. And for that reason, we actually interview every candidate who is coming into the school so that we can ensure that we have a better picture of the whole student and not just the numbers. And that's one of the things that I think is terribly unfortunate about the conversation, is that not this conversation, but the broader diversity conversation, is that so frequently diversity is actually set in opposition to quality. In a way that I think is both afactual and just very unhelpful to the broader conversation. That much of the work that our admissions teams are doing is about predictions of success. And so we are using GPAs and standardized test scores as helping us make some assessment about the relative quality of a student. But that's all that they are. They're just predictors of success. And so if we are being honest about that, there are lots of other ways to predict the likely success of a student, grit being one. And so if we remove the mythology around what high test scores and high GPAs actually mean, then I think it is easier to have a more candid conversation about what holistic admissions looks like without suggesting that diversity and quality stand on opposite sides of some spectrum when in fact they don't.
Other questions, Alex?
Another person, I'm going to guess this is a law student, because only a law student and maybe Roger and myself are geeky enough to have listened to the court arguments. Writes, there was discussion at the court's hearing about dropping legacy students. Can you explain how that could help? This wouldn't be for UMB, but at Harvard and higher institutions like that, private institutions. Can you explain how that would help open the doors for more students of color?
So, and Mark, feel free to jump in. Go ahead.
It's worth noting something interesting here, and that is at elite schools, approximately 75% of all students are non-racial preference students. They are children of donors, children of faculty, children of alumni, athletes. So the first thing dropping some of these preferences would do was it would politically, there were people who feel squeezed. If it's only 25% of the class, that you're in competition for, which means, by the way, your scores and your qualities have to be considerably above the average. And now someone says we're going to make it 20 or 15. Well, if we were to sort of drop alumni preferences and make it 55%, that would be politically powerful. And remember, alumni preferences. I can speak from experience. I applied to Harvard. There was a page. What did my ancestors in the Harvard class of 1804? None of my ancestors spoke English at the time that happened. I presume none of Renée's ancestors were eligible to go to Harvard via 1853. So it turns out legacy preferences codify race discrimination. If you get rid of them, it's simply more spaces for African Americans to compete against everybody else.
Renée, and I know you were chomping at the bit to get in there. Anything to add on that question?
I was just going to echo exactly what Mark said, right? That legacy preferences, because of the history of race discrimination in this country, legacy preferences frequently privilege white and affluent students and disadvantage other students. And so for all the reasons that Mark talked about, getting rid of legacy preferences would help.
All right, another anonymous question. And I was waiting for someone to bring this up. We didn't talk about the specifics of the Harvard case, which is really, maybe not for you lawyers, but for everyone else, a little bizarre. Person writes, in certain legal cases, and I think she means Harvard, the plaintiff is alleging that the university discriminates against Asian American applicants by rating them lower on traits like leadership and likability and holding them, therefore, to a higher standard for admissions than other applicants, such as Black and Latino students. Any comments?
That is the allegation. That is all that I would say.
I'll add something that I don't know the Harvard system at all. What I do know is in the 19th century, there was a stereotype of Asians. And it wasn't that Asians were dumb, it's that Asians worked all the time. That they weren't gentlemen or then gentlewomen. So they lacked the quality we really wanted in the Ivy League. That we should be aware that some of the stereotypes of Hispanics are different than the stereotypes of African Americans, different than the stereotypes of other groups, that it's possible, and I don't know the full history, that these stereotypes continue to exist in our system, which is another reason for a critical mass to see the full spectrum of the Asian American, the African American, the Latinx experience.
I will note there's a lot of chatter out there about how to appear less Asian on your college application. So that must be something going on to that. One other question, this is more to us. He writes, how will UMB specifically be affected if, and I assume what he means by that is if Grutter and Bakke are overturned, how will we specifically be affected, and are there programs we already have that help us recruit underrepresented groups that are race neutral?
So just from the law school perspective, and then I would encourage Roger and Diane to jump in from the campus perspective. So from the law school perspective, we have long recruited the whole student. We have long recognized that the whole student is what is important. And so, like I mentioned earlier, we read the entire file, we interview candidates. We are constantly working to ensure that our incoming class is a class that is going to encourage robust intellectual engagement inside the classroom and in co-curriculars and in every other space. And so we will continue to do that work. We will also continue to work with the schools within the UM system to make sure that not just College Park, but UMES and Morgan and Coppin and Bowie, that we are recruiting students from across all of the schools in the system in ways that will help to ensure that our incoming classes represent a variety of worldviews and lived experiences.
Diane, anything you wanted to add?
Well, predictably, I can see that anything that we have that's focused on a particular population in terms of funding, we will have to revisit because that could be deemed illegal. And so some of the strategies we talked about earlier around hires and programs and some other things will need to be revisited. Now, if as a graduate of an HBCU at the graduate level, Howard University, I know that since 2016, the 2016 election and 2020, with the racial reckoning, the triple pandemics and so on, students, including members of my own family, although given choices to attend other institutions, chose an HBCU or chose a women's college. And so we are going to be in increased competition if students believe or feel that their race or ethnicity is a disadvantage in a state public institution application. And so we are going to have to think creatively and act urgently in terms of funding and how we design our programs to attract, retain, and to create a kind of climate for those students as well.
Yeah. In preparing for this, I was reading perhaps a Washington Post article, and they were interviewing a student from Michigan who was an honor student and likely would have, and perhaps was even admitted to the University of Michigan, but opted to attend Howard. So obviously Michigan was competing for this student, and Howard was competing for this student. And the student opted to attend Howard because she didn't want to attend an institution where she was the only one, or likely be in a class where she was the only one. So if we gotta, and we will, and we already are, quite frankly, in competition with our peer institutions and others for underrepresented minority students, that will continue. And it's going to be harder to recruit students to our institution. So we're gonna have to, as an academy, share information, ways, strategies that work, learn from each other, even as we're in competition with each other for a lot of these students. Alex, I know you have another question, and I want to get as many questions in as possible.
Sure, I'm going to bring in Manuel Evangelista.
All right, thank you. So thank you for doing this. And we want to ask, in your perfect world, and I guess that's still subjective, how would you actually do college admissions? And I understand that each institution have different policies and funding and so on and so forth, but in general terms, thank you.
Was the question, how do you do college admissions?
How would you actually do college admissions? What if you're in charge of this the whole conversation here? How would you actually promote whatever we're discussing here in terms of how would you actually make changes? Or
Renee, I was going to tee up a similar question. Hopefully it's a similar question for you, which is, let's assume worst case scenario. Affirmative action, as we know, it is overturned by the court. What does that do for you as a dean? How does this change the strategies you've adopted now? What would the strategies you would adopt going forward look like in terms of trying to maintain that commitment to seating as diverse a class, racially diverse a class as possible? What does your life look like post an adverse decision as it relates to affirmative action?
So I think candidly, a part of it is that I need more people on the admissions team with eyes on files, because it's going to require not just relying upon the shortcut of scores to seat a class. It's going to require, much of what we're doing already, but at a more comprehensive level, not just the interviewing of every candidate, but, really doing a deep dive into all those files to make sure we understand the whole person. I think that one of the things that we know is that talent is not segregated by zip code, but opportunity is. And so if we want to break that reality, we have got to work hard on the admission side to ensure that we are doing a fulsome job of identifying talent and recognizing that talent cannot just be boiled down to standardized test scores, that talent means much, much more than that. And so working very hard to identify all of those various predictors of talent in a student or in an applicant's file. So in our world, it just means more people, because the review of the files is going to become much, much, much more robust. We're already doing much of that work, but in a post-decision world, we're going to have to be much more intentional about doing that work.
Mark, I'm not sure we talked about this, Mark, in our prep session for this conversation, but maybe I could put you on the spot, just to sort of like make sure we're looking at this or talking about this from all angles. And I know we have another question. So of the argument, and I know you listen to all the arguments, of course. What would you say is the best argument you have heard for overturning the precedent, affirmative action precedent, as we know it now? Not that you necessarily agree with the argument, but what's the strongest argument put forward by any of the lawyers arguing before the justice, you would say?
I think the best argument put forward is something we got in an ideal world. We have lots more people reviewing applications. The good news is that, in fact, the Republican Party, in return for overruling Grutter, has given millions of dollars to all law schools and universities to hire admissions people. And in fact, it's a better way, rather than to use race to get at diversity, experience with discrimination. It's a better way. The problem is, it's a better way that requires funding that this society is not willing to give to education. It's sort of, we may say it's almost the same problem with abortion in Mississippi. As someone noted, Mississippi claims they value, unborn life, and they don't spend anything on prenatal care. They don't spend anything on pregnant care. Well, we claim we value sophisticated methods of getting at what affirmative action is, and we don't get the budgets to do it.
Thank you. Alex, you have one more question, and I know the clock is running on us here.
I do. Mary Phelan from our staff senate has the question. I think, Diane, this is the question you've been waiting for. Mary, you want to go ahead and ask it?
Hi, thank you, Alex. How important is it to have a diverse staff when you're out doing the work of recruiting? And what steps is UMB taking to make sure that there is a diverse staff that is trying to get the most qualified candidates?
Hi, Marion, thanks. I can speak to the first part of it and the practical components in the schools. I'll leave it to both Provost Dean Ward and Hutchins on that. So representation matters, as well as identification, racially and ethnically, and on every other way that we can think about it. Earlier, I mentioned the UC finding Our Own Money and Love, again, a more comprehensive study. Part of understanding cultures is not only about the cognitive experience of it, but also the lived experience of knowing what Indigenous or Native students or what Black families need, or Hispanic/Latinx families need. The ways in which we recruit those students might be different from the way we recruit a student from the Midwest who is white, who is affluent. And what I mean by that is often it's not that they're sending the student to school or to university. They are sending the neighbor is coming with them. Abuelita is coming with them. That's the grandmother. It's the godparent. It's the person who sold on the street or whatever it is, of course, and their parents where that's relevant, and siblings. So it's a full community effort. And so what it means is, one, there needs to be identification and understanding of who that community is, and they can see themselves represented in the staff. And the other part, once they come to the university, is, are there people there who can both culturally and responsively share tips for tutoring, coaching, advising, where to find things, how to cope with the new change, because some are first generation students. And then I wanted to put a plug in here for, we can't underestimate the power of training in and around bias, both when reading the essays and working with students and with each other. So a diverse staff is helpful, is needed, and we need to continue to develop them. And then I'll turn it to my colleagues around what's being done in the schools around that.
Renée, what does your staff look like?
So we have a wonderfully diverse admissions staff, which we also complement with an admissions committee that of the faculty that is very diverse. And I am always available to go. I go on recruitment trips all the time to try to as Diane said, if students or if applicants will identify with me as the leader of the institution, then I want to be out there to ensure that I am speaking to them in all the various forms of diversity that I bring to the institution, which I think are far, I think we can be reductionist in our understanding of diversity and what it means, and that we want to make sure that we are being broader than just race and gender, that nobody is just that. We want to make sure that we are understanding the whole person.
All right, Alex, you might be able to squeeze one more in.
Okay, one more in. You can always tell when it's written by a lawyer, and I don't mean that in a bad way, but it's so perfectly written. It's addressed at Mark. Professor Graber spoke about race-neutral admissions criteria at a magnet school that were challenged as being discriminatory because they were intended to benefit underrepresented minorities. If legacy admissions have the same impact, have the impact of necessarily disadvantaging underrepresented minorities, why are they not also being challenged as being discriminatory?
Can I simply say, good question? And by the way, Dean Hutchins, we have clinics in the law school. Maybe we should run that at some of our clinicians.
That is not a bad idea.
Well, it is outstanding to end this conversation with a great idea and an outstanding question that maybe we get to poke at a little bit and discuss further at some point. But let me end by thanking all of you. First, thanking the panelists for making the time today and participating in what I found to be quite an engaging conversation. And I trust that the participants, the audience, did as well. And speaking of the audience, thank you as always for tuning in and making time in your day, even as you get ready to head into the holidays. And with that, thank you for your time, your engagement, and I wish all of you a healthy, restful, peaceful, relaxing holiday season.